Hello. Hello, Devjani. Wait. I will unmute you. Wait.
So I'm keeping the video off till then. Is it okay? So
Hello.
yeah, hi.
Yeah, yeah. It's anyway another. How? Hello.
Hello.
कैसे हो? ठीक हो?
Yeah. I'm just connecting my
Mm-hmm.
headphone. Just give me a moment.
Yeah, it's audible. ठीक है.
But actually मुझे सुनाई नहीं पड़ रहा है.
ओके, हाँ ठीक है. फिर आप हेडफोन कनेक्ट कर लीजिए. कनेक्ट कर लीजिए. नो इशू.
जी.
Just wanted you to log in. The slides, everything perfect. No, is it working?
Actually आपका आवाज बहुत feeble आ रहा है.
नेटवर्क इशू होगा.
So
Slide is okay. Slide okay. Can you share that screen?
I'll do that right away.
Yeah.
Hello.
Yeah.
Yeah.
Share.
Now, हाँ जी.
हाँ now you can hear. सुन सकते हैं ना?
Okay. Yeah.
हाँ.
Perfect. So I'll just
एक बार चेक कर लेते हैं. If it is fine or not?
yeah. Absolutely.
Yeah, just share it.
Yeah. Just a second. So you have to guide me a bit as to how I can.
Just open the Zoom. No, your screen. Share screen will be there. No, green color.
I don't know why I can't see it because the Zoom is open. I can only see you on that. So
No.
okay, yeah, I'm just doing that right away.
Yeah.
I got it.
Yeah. Bottom line. No, that.
I got it. The green color icon.
Yeah. Right. Just click it. You have saved on desktop your folder.
Yes. So I'll just share.
Yeah. Just let me see. Yeah. Fine.
Yeah.
Yeah.
So
It's
maybe.
let it be like that only.
Uh-huh.
Minimize. When we will start, you can come to full screen. Like.
So we are starting in 10 minutes, right?
Yeah. Right. So let
Okay.
it be. No. Now already.
Yeah. Okay.
So how are you? We can talk 5 minutes.
Yeah. So I guess we have many other participants as well, right?
Slowly they are coming. By
Yeah.
12 they will come. I am just putting reminder in group.
Sure.
So if you not tell your, even I put in Kelly alumni groups also. Some you
Yeah.
will find some old friends.
Yeah, I can see some of my juniors actually. I can see Shilpa. Yeah.
Fine. Then still people will come slowly. I
No
think
worries.
Sunday no everybody wants to enjoy. So sorry to disturb you on Sunday.
No. Please don't say so.
I took
It's an honor.
because everybody get one Sunday, so you also, and yes, it is more difficult, right, to get the time. So how the things are there, Johnny?
Things are fine, sir.
I think after around 20 years, after 20 years, I am seeing, no, we are seeing each other. During B Farm, I
Yes.
had seen you.
Yes.
You was in
Yes.
final year.
I'll just like pause my video for 2 minutes.
Yeah, no issue. No
Yeah.
issue. 12 o'clock we will start. No problem.
Yeah.
Okay. You can pause. Then we can, or else I can only.
Yeah. For
Then.
I don't know why I'm unable to. Okay. Yeah, I got it. I got it.
Yeah.
Yeah.
Yeah. Now it is pause.
Just
So
for
when
a
you
minute.
start,
Yeah. Just for a minute.
no issue. No issue. So good morning to all participants. We will start by 12 o'clock. We are waiting for others to join. Slowly people are joining. Please wait till 12. and then we'll go for that. Yeah, there's Johnny.
Hi.
Back?
Yes.
Yeah, another 5 minutes.
Sure. Not an issue.
So 12 we will start.
Sure.
How are you? Had your breakfast?
Yes, of course.
Tea
What
or
about
coffee?
you?
I just finished my daily work and ready on time to meet my college mate, my alumni member, my alumna of our college. Correct. So it always give a pleasure, right? No, when we meet our old friends.
Absolutely. And that is why last year I had come down, but unfortunately you all were not there. I could meet Prasanna sir
Uh,
and Shiv Kumar sir. So is Shiv
yeah,
Kumar sir joining today?
Sukumar sir, I told, I think he will join. Even Prasanna sir also said he will join.
Oh, wonderful.
So they join, it is good. But I am more worried that our students should join because they need this guidance. They need to know about patent and about the career options,
Yeah,
especially. Hmm,
and like I have kept it more, student centric because, and so I just kept it at a very beginner level, at an entry level when we
yeah.
get into the uh, patent field in this particular domain. So,
Hmm,
like, what is expected out of us, especially nowadays, like things are like becoming very competitive, extremely competitive, and nobody wants to take in freshers.
yeah, right,
That
right.
is the harsh reality that we have to actually face.
And
Like,
it is happening.
yeah, it's there.
So 12 o'clock or 12, 5 minutes, can we wait 5 minutes more?
Absolutely. Yeah, yeah, yeah.
You have any other busy schedule? Any planning?
Sunday is actually the busiest day of the week.
That's why I said sorry in beginning only.
No, it's okay. But other than Sunday, I couldn't have managed actually because work takes up the entire like 12 to 15 hours of a day nowadays. during lockdown.
Because you know now the students now slowly they are turning up. They won't come immediately, right? In Indian time, no. 12 o'clock means 12:05. They will think. So do you have any contact with your seniors?
Can you name some?
Your batchmate,
My
you name.
batchmates? Yeah,
Yeah,
my batchmates. Yeah, yeah. Though they I have contacts with, like Thontesh is there in
oh,
Apotex Bangalore.
yeah, yeah. He had come once also for alumni meet.
Okay, yeah. So you should
Umamedam,
actually ask him to give a talk as well.
but I don't have actually. Once I put message in group mail through mail. Maybe that mail he is not seeing regularly. So if you have details, just provide me the
Sure.
WhatsApp number. Or,
Yeah, I'll do that. So
because
Thontesh I'm regularly in touch with, and Dharmesh is in
uh-huh,
Sudan, and
uh-huh.
Monata and Vinci, like they are there in Bangalore, of course. And I've shared the meeting details with them as well. I don't know whether they will be able to turn up or not because Sunday is a busy day for
Yeah, yeah.
working women and working mothers. So
So you do you remember Salin sir?
I know Salin sir very well.
Yeah. So I am planning one talk from him also. He
Next
had
week,
agreed.
right? Next week,
He
right?
next week now due to Ganesh Puja, no Mohit, my batchmate Mohit Patel, he said he cannot. But
Okay.
on Monday we have Gopal Pawar talk from Birmingham, 31st.
And what
30,
is it about? Centered on?
about this your ADME methods
Oh,
and
perfect.
yeah,
Uh-huh.
he will join all these the points ADME and medicines no in hospitals and all that. So he's doing some USFD project in UK,
In
UK Birmingham.
Birmingham. Okay.
So it will be nice talk, and then Mohit will
You
talk
said
about.
Mohit Patel,
Mohit Patel will talk later.
the tall guy.
Yeah, yeah, Gujarat, fair guy.
So you were in Indra Didi, Jinu
Yeah,
Didi's
yeah,
batch.
yeah, yeah. Where is
Oh,
Indra?
okay. I'm sorry.
Indra, where is Indra now?
Indra is in the US. Jinu is also in US.
Okay.
And yeah, so I know Mohit Patel very well because he has done his M Pharm from Bombay College of Pharmacy, BCP. So, and all my colleagues out here are from BCP. So then we talk, we used to talk about him. Now, like, we hardly get time to talk. It's only work, work, and work now.
So I think now we should start. It's 12 o'clock. You are also
Sure.
getting late, right? No? Ready?
Yeah.
Okay. So let
Yes.
me introduce, and then you can introduce about yourself, and you can. So here we go. Good morning to one and all participants here. On behalf of Honorable Chancellor of Kelly College of Kelly University and Belgaum, Dr. Prabhakar B. Kore sir, Honorable Vice Chancellor, Dr. Vivek A. Saoji sir, Registrar, Dr. V. A. Kotiwale sir, Head of the today organizing committee, Professor Dr. Raman Dang sir, the Honorable Principal of Kelly College of Pharmacy, Bangalore, and I. Sujit Kumar, coordinator of today's presentation, as well as Secretary of the Alumni Association, Kelly College of Pharmacy. Welcome everyone on this Sunday for a wonderful talk on the patent and patent litigation 101 by our distinguished alumna, Dr. Devjani Banerjee. Friends, we all know that whatever idea we have, whatever innovations we have, it must be preserved, it must be protected before somebody it gets stolen by someone else, or it gets copied by someone else. So what are the technical issues, what are the points, and what are the career options in this field? All these aspects will be discussed by Devjani Banerjee, and I will request Dr. Devjani Banerjee to introduce herself and go ahead with the presentation. Devjani, please.
Thank you, Sujit. Thank you for the kind words of introduction. And so, thank you, Dr. Dang. Thank you for giving me the opportunity to talk about the work that I do on a daily basis and to introduce the concept of patents and the career options that students these days can opt for in the patent department. So thank you for the opportunity. So I am a alumni of, as Mr. Sujit mentioned, I'm an alumni of KD College of Pharmacy, Bengaluru. I graduated in 2004. After that, I went on to complete my Masters of Pharmacy from BITS Pilani, and I followed it up with my PhD from BITS Pilani under Dr. D. Sriram. So I did it in the field of medicinal chemistry. My like dissertation, my thesis topic was on the synthesis and characterization of anti-HIV, anti-TB, tubercular drugs. So after that, I joined the patent department, the intellectual property cell at Sun Pharma in 2009 December, and since then, I am still with Sun Pharma, working here, and my job here involves patent landscaping, then due diligences, and patent screenings, and freedom to operate. Uh, and all of it. So I will talk about it more when I come to the career options that I present at the end of the talk. So before that, let me begin by uh, giving the brief background of what exactly is a patent. So, so what exactly do you mean by a patent? So a patent is like whenever like somebody invents a new or a useful, it has to be a new thing which somebody before you has not like had the idea to come up with. So if you have come up with a new machine, a new compound in terms of the pharmaceutical field, if it is a new composition of matter, a new molecule, a new formulation, something like an IRXR combo, or something like a time release formulation, or a different use of of an old molecule. These are things for which you can get a patent on. So what are patents? So if like what are the key tenets of patents? So patents to begin with are territorial rights. So that means if I apply for a patent in India to the Indian Patent Office, so it will mean that my invention is protected only in India. So if I don't go and file a patent in US, that means anybody, any US citizen or anybody in US can practice the same invention if I have not applied for, and if I have not been granted a patent in US for the same invention which is patented in India. So if you see, it is a territorial right, and it is only applicable in the country or region in which a patent has been filed and granted in accordance with the law of that country or region. So there are differences. So if you see, the key operative word here as is that it is in accordance with the law of that country or that region. This implies that there are differences in the patent laws from country to country, from territory to territory. Like there are certain laws which are applicable only in India with respect to when you apply for a patent in India, whereas those are not applicable in US. Now, second tenet is patents essentially are negative rights. That means that it is a exclusionary right. It does not mean when you have a patent, it does not mean that you have to utilize your patent completely, but you can stop anybody else. If I have a patent, I can stop Mr. Sujit from using that same invention for a term of 20 years from the time that I have filed the patent. So that means that patent protection, it means that until and unless, it does not mean that like you have to distribute something, you have to manufacture something, you have to sell something uh, in order to so that your patent would be in force. Then again, when I come to the next slide, you will see there are differences with respect to the different geographies. But if I am granted a patent, I can stop anybody to practice that invention. The operative word is practicing. So I can stop anybody from practicing that invention in a commercial scale without my consent. They can, of course, I can, of course, a patentee or a patent owner can, of course, they can license the patent in exchange for a royalty, or that is something like a voluntary license. I can enter into, like a patent owner can enter into a licensing deal with another person, with another entity who wants to practice my invention. And so in exchange, I can get a royalty deal, I can get monetary benefit. And so this is all it is about, right? It's money which talks in today's world. So as I said, it is an exclusionary right, it is a negative right, and it is not a positive right. But there is a caveat to it, there is a little difference which I'm coming to in the next slide. So you see, in India, this is a particular like provision which is unique to India, and it is not there in other geographies like in US, in Canada, and Europe. This particular provision is not there. This provision is called the working of the patent. So every patentee or every patent owner in India who has been granted an Indian patent has to submit that they are working the patent in a particular form called the Form 27. So they have to furnish a statement stating every year they have to submit that they are utilizing the patent which has been granted to them for, and they're utilizing it in a commercial scale, not only in a research scale. So if that is not done, if a patentee is not following that, if a patentee is not working their invention in India, so then the Indian Patent Office can step in and can like grant a compulsory license to somebody. Suppose there is a medicine, like especially in the in our field, in our pharmaceutical, this is very relevant. If an MNC company has applied and has been granted a patent for a life-saving drug in India, but then they decided, they chose not to commercialize it for whatever reason it might be, but then what is happening is that the patient community at large, the people, the general public at large, is not benefiting from that particular invention. So then another Indian company, somebody like a BDR Pharma or an MSN or even Sun Pharma, can say that we have the capability to manufacture and supply to the general public, and so that the general public would be benefited from that particular drug. So, and if that particular MNC, so-called the big pharma, are not actually supplying the drug to the patient population, so then the Indian Patent Office can step in, can either revoke the patent or can grant a compulsory license to such company who are applying for it and who have brought this to the attention of the Indian Patent Office. So I'll move to the next thing, which is the very crucial thing, the term of the patent. So term of the patent generally, so I have, again, this is again, as I said, patents are territorial rights. So basically, like, there can be and there are differences in the patent terms, like between one geography to the other, and from one type of patent to the other. Like I have started with US. I have in this slide I have captured only the US patent term details, because you know US is the key markets, especially for the pharmaceuticals and especially for Indian generic pharmaceutical companies, in which like most of us are working, or like 90% of like us, like who are graduates from like different pharmaceutical colleges, are we work in like the generic Indian generic pharmaceutical companies in India, right? So then, and the Indian generic pharmaceutical companies, they generate most of their revenues from selling their products by selling their, by commercializing their generic drugs in US, because US offers certain incentives which I will come to later, in the later part of my talk. So in US, there were earlier, before the Uruguay round of the GATT. The operative, the date here is 8 June 1995. So before 8 June 1995, the patent applications which were filed before 8 June 1995, the patent term of those utility patents were either greater of 17 years from grant or 20 years from filing. This was there because they, like, at the US patent office, the office which actually prosecutes and grants patents, there were considerable backlog happening. And so then the patentees, they were actually their revenues, because patents, they like they it is a means of stopping genericization, and it is a means of like incentivizing the research done by all these big pharma companies. So that is the sole purpose of such exclusionary rights that are granted to such companies by virtue of patents or regulatory exclusivities, which we can talk in the later part of the discussion. So because of this, so they were, because they were suffering, so then the United States Patent Office decided that the patent term would be either greater of 17 years from grants or 20 years from filing. But the patent applications which were filed and which are still being filed post 8 June 1995, they get a date straight away 20 years from filing. That is, if today is 16th of August 2020, if somebody is filing a patent application today they can't file, it being a Sunday, but suppose they are filing today, so then the patent would expire on August 16, uh, okay, 2020, so 2040. So just imagine. So they will be able to stop everybody else from coming into the market with the same product till 2040. So till 2040, they will be the only person who will be able to sell and commercialize the product and get back the profits or generate the revenues for that particular company. Coming to design patents are actually different from the utility patents, and design patents are also applicable in the pharma domain, because when it comes to the drug device combinations, so on the devices we get certain designs, and so all these companies like Becton Dickinson, all these, basically these device companies, so they apply for design patents along with certain trademarks and trade dresses are also applied by pharma companies for for the finished dosage forms, as well like for the color, specifically the color, the shape, and all. Like AstraZeneca's purple pill on the esomeprazole is a very big case actually in pharma. Though it's not a patent case, it's a trademark case, but it had taken the entire pharma world by storm, because they had stopped literally everybody, even somebody who had come up with a pink color capsule also. They had said that it falls into the like they were falling within the ambit of their particular trademark. So design patents, again, they have a term of 15. Earlier they had a term and now they have a term of 15 years from grant, and earlier before 2015 they had a term of 14 years from grant. I'll move to the other jurisdictions. So in other countries, they have straight away, like Canada, Europe, India, Japan, Australia, they have 20 years from filing. Brazil, again, they have 20 years from filing or 10 years from grant, because Brazilian patent office is extremely slow in prosecuting any patent. They take very long, and so basically by the time the patent is granted, if the the pharmaceutical company had filed for that patent, so that 20 years term has already been subsumed within that prosecution period, and so they don't get to enjoy the exclusionary rights. So that is why the Brazilian patent office is still giving 10 years from grant, though they have, like, there are talks where they are working with the, like, they are recruiting more examiners, more patent examiners, so as to hasten the process of patent prosecution at the Brazilian patent office. But still we are seeing that they are like granting, like allowing patents with 10 years from grant. This actually has a negative impact on generic pharmaceutical companies like ours, or even the other like generic pharmaceutical companies. But yes, we have to take it with a pinch of salt and move on. Coming to the next topic, that when I said that like patents enjoy a 20-year lifetime, so is it sacrosanct? Does it mean that it cannot be extended beyond 20 years? So here I tell you about what are patent term extensions and patent term adjustments. So then, patent term adjustments are generally given or granted by the patent offices like USPTO specifically, for the time, for the delay that has happened to a certain patent application, due by, because of the delay at the patent office by the examiners. So that is called patent term adjustments. And what are patent term extensions? So what happens is, when a company files a patent, so at that stage, suppose a pharmaceutical, a big pharma, somebody like Novartis or Astra or BMS, suppose, or Pfizer. So when they file a patent, so that particular, like when they have filed a patent, their particular drug is quite early in the pipeline. It has not yet reached the stage of even where they have applied for their, they have submitted their drug for approval, or like the question of commercialization itself, can't arise now, because they have not even filed for approval. So when they file for approval, suppose with the US FDA, so then there is considerable time also spent by the US FDA reviewers in reviewing the dossier. So the delay that happens because of the time spent by the US FDA reviewers in reviewing all the data that is submitted by these pharma companies. So in order to give back, incentivize them, so that they can go on pumping resources into R&D. So that is why the US FDA along with the USPTO came up with the idea of patent term extensions. And so but there is a capping to it. They any company applying for a patent term extension can only get a maximum period of 5 years. So as I've said, that if that particular patent which got granted, like which was filed today, suppose that is for some molecule XYZ. So that this XYZ molecule is approved, like they this particular company, suppose my company, I apply for it, and uh, I apply for the patent, and suppose after 2 years in 2022 I go ahead and file the dossier for my XYZ molecule. And my molecule, instead of being like approved in time, there is certain like delay by the US FDA reviewers, by the US FDA office, and there is considerable lag, and my molecule is finally getting approved in 2030. But then I have lost 10 years of my patent term. So in order to give me back that time which is lost, where I should have been in the market by 23, 24. So the US FDA, in collaboration, in conjunction with USPTO, will grant me a maximum of 5 years of patent term extension. It's called the 35 USC 156. Maybe it's too much of detail, so I'll just leave that part out. So, and so US will give you a maximum of 5 years, and that will run after your patent, the normal patent term has expired. So if the patent would have expired on 2040, so then it would now expire in 2045. That, but that too, it is a maximum up to 2045, but that depends on like how much time was actually spent, by how much delay was there on part of the US like FDA. Similarly, the European Union also gives, it is called the Supplementary Protection Certificate, and that is a maximum of 5 years. And so if you see, I have mentioned in bracket here, in case of US, it is 14 years from the NDA approval. So if my drug is getting approved in 2030, so it cannot go beyond like 2044. So the extension can be only for that 4 years. And similarly for Europe, if it is getting approved in 2030, and so then my patent cannot be extended beyond 2045. This is the maximum. So Japan also has a maximum of 5 years. And in Japan, actually, it's like they are pro innovator. And what they do is like for one patent, you can get multiple extension, because suppose there is a particular drug, and take any anti-cancer drug. Now, when you say anti-cancer drug, so one anti-cancer drug can be like used for multiple indications. Can be for liver cancer, hepatocellular carcinoma, can be for ovarian cancer. So in Japan, actually, they allow like multiple extension depending on the indication. So Japan is pro innovator, so that is like a very good thing for all the big pharma companies. So Australia also similarly has a maximum of 5 years. Singapore, and then Israel has, and in Israel actually it's the expiry date is determined based on the convention country. Now the convention countries are countries like US, Europe, and all these Australia. So if in Europe they have given a patent term extension, and the patent term extension, by virtue of the patent term extension, the patent is expiring in 2045. So even in Israel, the same date would apply. Canada is a recent entrant to the concept of patent term extensions. They don't have adjustments still, it's just extension. But they don't actually need adjustment, because the Canadian Patent Office, there's not so much of delay at the patent office, like a lot of back and forth does not happen, where the examiners, reject time and again, and then again the applicant has to rebut. So all that doesn't happen like how it happens in US and Europe. It doesn't happen in Canada. It's very straightforward actually. So, but they have started giving out extensions, and it is only a maximum of 2 years. China. So China is the latest entrant actually, and they are giving a 5 years for the delay. So they are giving 5 years of extension, and China is right now the like the new US actually, you can say, in terms of providing incentives to whether it's a generic pharma company or the big pharmas, the MNCs actually. Uh, so which are the countries which does not give patent term extensions? Of course, India. India actually is tops the list over there, and it leads actually. So India is a big influencer when it comes to influencing on terms of what should not be given, like patent term extension. It doesn't give at all. And now Brazil, Mexico, all these countries are following in the footsteps of India. So I'll move to the next slide. Okay, so I have put this slide here from a very India perspective, because I know that we have got many Indian inventors, and everybody's keen to protect their invention. So, and they will start with India because all of us mostly are based out of India. So, I have, that is why I've kept only a very brief this about the different stages of patent prosecution as to how it moves. First, like you apply the provisional if you want, or you can also apply the complete specification with the complete application you can file. And then after that, so after 18 months, like it will be the published. So when it is published means anybody can see, it's open for public review. After that, the patentee has to request for the examination, and then the FER is issued. So the FER is the first examination report. So where the Indian Patent Office examiner would tell you, this is the reason why we feel that you should not be issued a patent. These are the like they can find something which is somebody has already done. So, and after the FER is issued, so you will get, like the patentee would get a time of 6 months, extendable up to 9 months. Between that 6 months and 9 months, you have to then respond to the FER. So, and after that, like there can be a pre-grant opposition stage, because it is there already in the public domain, so people are aware as to what you're trying to get a uh, patent on, what your claims are. And so based on that, somebody can actually object and they can oppose. It's called a pre-grant opposition. So after the conclusion of the pre-grant opposition, then like there can be further, it can go back to the patent office again, and like there can be a further examination, a little more back and forth can happen, and it can be granted. After that, there's a post grant opposition stage here in India. So these are the different stages that I have listed. uh, I will move to the next slide. So this I was not sure as to how many amongst the audience has seen how a patent looks. So that is why, with that sole purpose, I have kept this. So if you see to the left, this is a US patent, and so this is the first page actually of the patent. So it will give you all the information about when the patent was filed, when the provisional was filed, when the patent was first published, when it was made open to the public, when it was granted. So if you see, date of patent is May 28, 1996. This implies the date of the grant of the patent. And then you'll have the title. See, if you see, pyrimidine derivatives and processes for the preparation thereof. So this is actually a patent on imatinib. Imatinib, I hope everybody is aware of. It had taken the entire Indian pharma world by storm. Uh, like when like there was a case actually between where Supreme Court had denied them, denied Novartis. Novartis is a patentee, so Supreme Court had actually denied Novartis a patent on their specific salt, the imatinib mesylate salt. So this is actually the imatinib base patent. So here you will see all the information, like the abstract. So like the abstract is what basically the inventors are trying to claim. And so all of that is listed here. On the right side, you will find the European equivalent of the same patent, or little difference. Other than the fact that like the bibliographic data here is in German, but then there are a little difference between the US patent and the European patent. This is how the first page, the bibliographic page looks, or we also call it as the face of the patent. Now I will come to the different parts of the patent. So what are the different parts of the patent? So as I showed you, first there would be the bibliographic data, the face of the patent. Then like there would be something called the specification, where you give details about your invention, as to what you have done and what led you to what was the suppose if there is a particular uh, a pencil. Suppose there is a pencil which now has an eraser. So if you say that, like, earlier there was a pencil, but then because there was no eraser attached to it, so then students used to always find it difficult during an examination to erase something what they have written if they have written something wrong. So your invention is that you have clubbed the two. You have put the eraser and the pencil and you have made it into one particular device. So what you are basically trying to justify is that what was the problem there in the in what was existing before you came up with your invention. And then you would go on to talk about how your invention would benefit the public at large, how it has a commercial application, and why it is novel. I will come to all that later. So that is there in the specification, and you would also give, like, there would be figures, like in especially in case of like the pharmaceutical field, we rely on a lot of figures and data. Like the suppose you have come up with a new crystal form or a new salt. So when you have come up with a new crystal form, so you would obviously characterize it. So how will you characterize it? You will use XRD, X-ray diffractogram, or you will rely on differential scanning calorimetry, you will rely on thermogravimetric analysis. So all of those data, so which you are generating in your laboratory, so all of that you will put in the figure. So all that becomes part of the patent specification in the figures. So that after 20 years, when your patent expires in 2040 or 2045, so what happens is at the end of the patent term, when the patent has expired, it is like dedicated to the public. Now anybody and everybody can practice your invention because you have enjoyed the monopoly for 20 years. The government has given you the right to stop everybody from using it, and only you can exercise that monopoly. You have done that. So after 20 years, when somebody practices that invention, they should be able to practice it as it is delineated in your patent. So they should be able to say, they should be able to compare that, is this what I have done? Is this matching? So if you have come up with an alpha form of some XYZ molecule, so is this XYZ molecule? So when they look into the figures and they compare with the XRD that they have generated, they should be able to compare and match it. So that is why they have figures. And the specification also has working examples, like if you are making a particular composition, so how have you made it? What was the technique? Like, have you added, is there a particular like sequence of addition of the excipients, like you have added the disintegrant first, or you have added the surfactant first to the API, and then added the diluent, and then you have performed the wet granulation technique? And what was the wet granulation technique? Have you only relied on a specific wet granulation technique, or it can be applicable, like your the specific composition, suppose the specific tablet or the whatever kind of composition you're coming up with, like the finished dosage form. So is it only generated when you use a specific technique, or across the class, like wet granulation as a class you can just use and you will still end up with the same kind of composition? So that is what you talk about in the specification. Now coming to the very important part, which is the number one here, which is the claims. What are the claims? So your claims in patent parlance, they are called the metes and bounds of your invention. So that means, like, they are the boundary. You have a house, but where does your house end? Because after your house there is a road, maybe the highway starts there. So where does your house ends? So your house ends at the boundary, the fencing. So the claims are the fencing. Beyond the fence, it's not your house, it's not your property. So claims define that beyond which you cannot actually get an invention. So these are your myths and bounds. So here I've just given, like I've just pasted just a representative claim. So if you see, this is an N-phenyl 2-pyrimidine derivative. This is again the same imatinib molecule patent, which I had pasted earlier. So this is the General Marcus claim actually. This is a very long claim, and I did not, of course, put the entire thing because then it would take up like one entire slide. So uh, I have just tried to give throw some light and make people aware of how the claims look. So these are the claims. Now coming to the most important part as to uh, on what grounds can you ask for patentability. So basically it has to tick three boxes. It needs to have a usefulness, a utility, and industrial application, that is. So in some geographies they call it utility, like US. In some geographies they call it industrial application, like in Europe. It has to be novelty, so that like nobody else has actually come up with that idea. It should not have been there in the public domain. Third is it should be non-obvious, or it should not have been, it should not have involved an inventive step. So I'll go one by one on it. So before I go to the three key requirements of patentability, I will also like to talk about as to what is not patentable. So you see here, this is just for like I just posted some pictures. I pasted these pictures of some demonstration that were happening, so that like just to make you aware of what's coming in the next slide. So these were like people had protested against a particular company which was trying to actually patent genes, human genes. So this is a protest. If you see here, this lady here is carrying this black placard which says Myriad Genetics, your corporate grid is killing my friends. So when I talk about in the next slide, you'll understand as to what they are saying. So here I come to the subject matter eligibility, or what is unpatentable. So what is unpatentable? The first is frivolous invention. What do you mean by frivolous invention? So if somebody comes up with a device which will enable you to hack into people's email accounts, that is a frivolous thing. So that is something which you cannot get a patent on. Or something like which will enable you to, people do gambling, right, in casinos and all. So if you come up with a method or a device which will enable you to like crack every gambling and win at every stake, so that is again unpatentable. Also something also uh, things like which are contrary to well established natural laws, like perpetual motion machine. Now there cannot be a machine, people are still working on a perpetual motion machine actually, but if you see the laws of physics, there cannot be a machine which goes on working with 100% efficiency continuously. It cannot go on working. So this is something which cannot be patentable. Mere discovery of a scientific principle, like all these mathematical like methods, they cannot be patentable. So I have covered it here as well. Mathematical methods, business method, computer programs, these algorithms, they cannot be per se, they cannot be patentable. Business method in Canada are patentable, but in countries like US, India, they are not patentable. Also, discovery of any living or non-living substance occurring in nature, these are cannot also be patented. Like someday some ornithologist goes into the wild and comes up and discovers a new species of bird, or somebody finds out a new species of a butterfly, they cannot patent it because it was already occurring in nature. There is no man-made intervention. There is no human intervention in that. So that cannot be patented. So these are the things. So as I was talking, I will also talk about a little bit on, just please give me a moment and I want to see. Okay. Yeah. So uh, I'll again scroll back to this slide because I wanted to talk a little bit about what was happening there. This was a very important case, actually. This was a landmark case and a landmark ruling. So, this particular company called Myriad Genetics, so they had actually like they had found the gene sequence and the mutation which was responsible for ovarian and breast cancer, which is the BRCA1 gene. I'm sure everybody's aware of that. So that BRCA1 gene, they had they had isolated that particular that gene sequence, and that was responsible for ovarian and breast cancer. So, and they were actually granted patents, and they had also come up with a diagnostic tool. So what they were doing is that they were actually stopping clinicians from using these particular the diagnostic kits to determine these patients who have these gene sequences and then who are susceptible to breast cancer and ovarian cancer. Now if you see, like majority of the, I cannot actually put a figure to it, but breast cancer and ovarian cancer in women throughout the globe is, like, I should not say it's a pandemic, but yes, it is a major issue with the with women's health these days. And so then people are like, women and their family members are worried that what if, like, if a mother has suffered and has, maybe like I was diagnosed with breast cancer. So then they want their daughters to be also tested for this. But because Myriad had a patent on it, so they were not allowing, or like other companies, they were stopping and they were enjoining other companies from, and even physicians, they were being enjoined to actually determine which of their patients have actually have these particular gene sequences and thereby are susceptible to uh, like breast cancer and ovarian cancer, and accordingly, the drug treatments can be tailored. So then at the end of the day, uh, Supreme Court said that because these gene sequences were are already occurring in nature, so then it was not Myriad Genetics like intervention. Myriad didn't have anything to do with the particular BRCA1 gene. So they cannot actually stop others from identifying which like who suffers from others. By others I mean the KOLs and the clinical physicians and the pathologists who were actually conducting these tests to say as to which patient actually has these genes and so are susceptible to uh, breast cancer and ovarian cancer. So this was a landmark ruling where they said that gene sequences cannot be patented. Nobody has the monopoly over these gene sequences. So I just wanted to make everybody aware of these. Okay. So I have already covered like this slide deck. So I will move to the slide this on the patentability eligibility. So in order to get a patent, your invention has to be novel. So I have quoted here the 35 USC. Uh, mm, I'm sorry, there's a mistake. This is not 35 USC 101. It will be 35 USC 102. 101 is the unpatentable subject matter. 102 is novelty, and 103 is obviousness, which I'll cover in the next slide. So this comes under 101. So it, as you see, it's stated, a person shall be entitled to a patent unless the claimed invention was patented, already patented, that is, described in a printed publication or in public use, on sale, or otherwise available to the public before the effective filing date of the claimed invention. So this is how the US patent law says about how your patent has to be novel. There are other certain criteria as well as to how like if even if there is something like in the art, how far it should be placed and how close, if it is, then whether it would be considered novel or not novel. Then the second part is the EPC, which is the European Patent Convention. So which says about whose article 54 talks about novelty, which is a key requirement for patentability. So it says that an invention shall be considered to be new if it does not form part of the state of the art. What is the state of the art? And this is very important. The state of the art shall be held to comprise everything made available to the public by means of a written or oral description. So here, if you see, oral description is very important here, because I know I have many of my lecturers here and even my colleagues who are working in colleges and are researchers, and so who go on to give on speeches and poster presentations. So if you have given a poster presentation, please bear in mind that you have to immediately also, within 1 year, you have to file a patent. Otherwise, if you're doing it afterwards, your own poster presentation or your own speech can go against you in getting you a patent. So that will hinder and hamper and will act in the way of you getting a patent. So please, these are things which I wanted to sensitize everybody to, that if you are going and giving a talk, and this is something which I tell all my like colleagues in R&D, that if you are going and giving a talk, please let us know. Because then after some days they come back and say, we want a patent on this, can we do this? And then we see that they themselves have a poster presentation. So it becomes very difficult for us to justify to them as to why they cannot, and like they find it very difficult to accept it. But this is a bitter truth. So if you have a plan of filing a patent, and at the same time, if you want to, I know we all want to go and give talks, but if you have a plan of filing a patent on the same topic, the same theme, so please be careful and mindful about it. So you see, what is the state of art? The state of art shall be held to comprise everything made available to the public by means of a written or oral description, by use, or in any other way before the date of filing of the European patent application. So this is on the novelty aspect. The second criteria, the inventive step. So inventive step, if you see, I have here only focused on the US and the European patent laws, because they are the ones like where like patents are very big in terms of like enforcing patent rights. They are like US, Europe, Japan, they are all pro patents. India is again all the more on pro generics. They don't respect the big pharma companies patents. And so that is why the big pharma company, you will see, they will always say that India is not TRIPS compliant, and then Mr. Narendra Modi will always come and say, or whoever is at the helm will say, no, India is TRIPS compliant. So these are the things. So there is always a trade war kind of thing which is going on. And it's all mostly it's concerning the pharma companies and the pharma industry of the two, like the geographies. So what is inventive step? So this is very interesting. So inventive step or obviousness, excuse me, is covered under 35 USC 103, which states a patent for a claimed invention may not be obtained, notwithstanding that the claimed invention is not identically disclosed as set forth in section 102. So I have covered 102 already in novelty. So you see that it was an exact replica. If you have made a pen with a pencil with an eraser, somebody already had a pencil with an eraser in the art. So if there was it if such a thing was there in the art, then you cannot get a patent. That becomes your invention is not novel, you will not get a patent. So now again I will use the same example. There was a pencil, you have just added an eraser to it. Do you think it's like you should get a patent? Anybody should get a patent for it? What's the big thing, right? It's obvious, right? Just to, because it's functioning. Again, it's not that you can use the eraser to write something, or you can use the pencil lead to erase something, right? It's not, you have not come up with a new use. You are using the you are using the pencil for the purpose of writing, you are using the eraser for the purpose of erasing. Only thing is you have clubbed the two together. So isn't it obvious to combine? So it becomes obvious to combine. So anybody, so 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 here again I come back that if the differences between the claimed invention and the prior art are such that the claimed invention as a whole would have been obvious before the effective filing date of the claimed invention to a person having ordinary skill in the art to which the claimed invention pertains. So if what was taught in the prior art would have told you, if the, suppose we all know that if there is a drug for which has a shorter half life, so if you like tweak it somehow to, if you make the IR to a ER so that the drug release is slowed somehow, so then isn't it obvious? Anybody can do like go from an IR to ER unless you show there was something in the prior art or something that was there before your invention which said that no, an ER formulation would not work. So if there was something, and despite such a teaching you go on to show, see, there was a teaching away in the prior art. uh, I want a little help. I can see on the slide deck some marks. Can you help me with that, Sujit?
It's okay.
It's
Sometimes it
not very
happens.
distracting, but I just wanted to.
Yeah, please
Okay.
continue. Next slide. I think you are touching something.
No, my hands are here.
Yes, it's okay. Continue. Sometimes it happens on Zoom.
Okay.
The next
Okay.
slide it won't come.
Hopefully, fingers crossed. Yeah. Um, so then, what happens is that it would have been obvious. So if it was there something in the art which specifically said that like the IR formulation would not work, uh, suppose that like it is supposed to release in the stomach, but whereas if you make it an ER it will release in the intestine, and so then like the purpose for which you are administering the drug itself won't be met. So then that makes it, that makes it non-obvious, and then you can justify to the patent office and get a patent. Otherwise, just if you're putting like 1 plus 1 is 2, right? Until and unless you show that 1 plus 1 is 10, like why should you get a patent? Also, if you see here in like I have mentioned it, I have italicized it, that patentability shall not be negated by the manner in which the invention was made. So which means that if a researcher has gone on to make a serendipitous discovery, like that was not the invention why he was conducting that particular research and experiment, but he ended up with something new. So that is something for which he can apply for a patent, and he will get the patent. So because he never intended to get a patent, suppose like uh, these days drug repurposing. Suppose you have a drug for a pain indication, but you go on to say that it has also it has the ability to dissolve clots, blood clots. So if there is something like that, so and if the inventor has found that out by like a serendipitous discovery, like I'll tell you, uh, there are certain drugs which were given for the purpose of ocular, to treat ocular inflammation. When they were applied, people found that the patients are having like their like the eyelashes length are going on like increasing, which is called hypertrichosis. So though the particular company and the researcher involved did not intend to use it for the purpose of hypertrichosis, they found it. They saw that this was an effect that the patients were having, and so they could get many patents on that actually. So this is a real life scenario which I just narrated. Coming to Article 56 EPC. So 35 USC 103 is the US patent of its view, and the rule and the law on obviousness. And Article 56 EPC is the European Patent Office's law, which says that inventive step is an invention shall be considered as involving an inventive step if, having regard to the state of the art, it is not obvious to a person skilled in the art. If the state of the art also includes documents within the meaning of Article 54, paragraph 3, these documents shall not be considered in deciding whether there has been an inventive step. Now, Article 54 deals with novelty, which I already covered in the previous slide. So I'm not again going back on it. So you see, like US and Europe are almost aligned when it comes to in terms of obviousness and novelty and the requirements for patentability. Okay, this is strange. Okay. I'm sorry, I don't know how this came up. Please do pardon me for it. Uh, I hope it's not like distracting people much. So if you see my, I'll go back to the this particular slide deck again, and I will show that what is in this particular slide. In this particular slide, the key operative words are prior art and obviousness. So, or state of the art and obviousness. So, these are the key operative words, the key takeaways, and I want the audience to please focus on this. So, when I go to the next slide, I'll talk to you about what is a prior art. So, what is the prior art? The prior art is anything which is currently available state of the art. So an invention that would have been obvious to a person of ordinary skill at the time of the invention is not patentable. So here again a key operative like phrase is person of skill in the art, or like person having skill in the art. They are called positors. So in US the patent term parlance, they are called positors. So who is suppose there is a particular patent on a pharmaceutical composition on suppose an extended release tablet, which uh, or a regimen patent. Suppose that there is a regimen patent which talks about once daily administration for 5 days of a particular drug. So then who would determine whether this patent would have been obvious? So we have to determine first, it's a legal analysis and a determination as to who is a person of skill in the art, who would say, whose judgment and expertise would say as to what constitutes the prior art. And would it have been like obvious in view of what was already there in the art? If suppose it was said already that a particular drug is given by an IR route, so when you give it by an IR route, then you need to administer the drugs 4 times in a day. So then, in order to then bring up the patient compliance, it's obvious then to come up with a drug where you are only administering an ER tablet once a day. So that increases your patient compliance. So if it was already there, if the T half of the drug was already known, if like all the other properties were known, would it, or even if suppose in the same drug category already an ER tablet of that drug was already there, so then wouldn't it have been obvious to a person of skill in the art to actually come up with this XYZ molecules ER tablet? I think it would have been. So this is a determination which the US examiner makes, and the US examiner may go on to then determine whether the patent is not it should not be, the patent application should not be allowed or granted, or should it be allowed. And suppose, so there are many back and forth which happens, many responses which go on between the patent office and the patent the applicant, where like the patent office, the examiner would reject the patent application, and then the patentee has to justify it as to why they deserve a patent on it. So if their justification satisfies the examiner, then the patent examiner will go on to, might go on to grant a patent. And even after the patent is granted, then like there are like people like us who step into the picture, and because we work in the generic side of the pharma company, and where we say that this is the reason why this patent should not have been granted, and we say that the patent is invalid. And that is like, I'll come to it in the later part. So so if you see here, like as I have stated here, obviousness is a key question of law based on underlying factual inquiries. So the patent field is like, it's not only very technical, it is a techno-legal field. So it involves like the application of the law of that particular geography, of that particular country, along with the knowledge of the pharmaceutical field. So what does the court decide? Court and the patent examiners decide. So what do they have to do in order to either grant a patent or not grant a patent, or to say that a particular patent is invalid? So then they have to determine the scope and content of prior art. As I was saying, that your if there was a particular molecule uh, on a similar class of drug which had an XR, and you are coming up with an XR of a newer second generation or a third generation of that class of molecule. So wouldn't it have been obvious, because in that similar class there is an XR already existing? So that is what the court and the patent offices would determine. Then the second step comes, which is ascertaining the differences between the claimed invention and the prior art. They have to determine what was the difference. Was there a huge difference, suppose in terms of maybe T half? There was. And so then, because this drug maybe had a longer half-life, so if the moment you have a longer half-life, why would you go for an XR? Do you actually need an XR? An IR is as good as that. It's already serving the purpose. So what was there a need? So this is the job that, or the task that is uh, handed over. I guess people have gotten bored and they want me to leave and stop talking. So that is why they are making it more colorful. So coming to the third stage, which is resolving the level of ordinary skill in the pertinent art. So this is what I was talking about as to who like whose judgment is like taking into consideration. So when it goes to the court, when a patent litigation happens and it goes to the court, so like the court would determine as to who is a person of skill in the art. So basically experts are roped in. Excuse me. And so then they say as to like would it have been obvious to them or not. So both parties would bring their experts and they would say, no, my expert is more credible versus their expert. So it's, you know, always these battles which go on. And so this is what I was talking about, resolving the level of ordinary skill in the pertinent art. After that comes to objective evidence relevant to the issue of obviousness. So this is called secondary obviousness, secondary consideration. So was there a market need? But like people were trying, like though it would have been obvious, like it would have been obvious to make an XR, but still like people were not able to, you know, come up with the XR or tablet. So there was an unsolved need. There was like others were failing. I can't hear you. You are on mute, Sujit.
I think someone is doing this.
Exactly. That's what I was saying.
Ah,
So can you stop everybody from sharing this? You know,
just one second,
yeah,
1 second. Because it is being done by someone for the skill.
exactly.
More option. Do you have more? Yeah, Mr. Dr. D. Narasimha Reddy, sir, who is pencil on the screen is activated. Is that pencil there on your screen is activated? Yeah, whoever is doing, it's okay. Just continue. I will sort out. I will sort out the problem. Please continue.
Because this way it's very difficult. How do I show it to them?
Yeah, yeah. I don't know. Is it not activated in your this one, right?
No, 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 not at all. Because my mouse is here, I was hardly
Please,
touching
people.
my.
See, someone is coming. More option. Here is more option. Host can do, I think. Yeah, please, you just discuss. I will do. I will solve this one. See, someone cursor is more. Please continue, Devjani. Please.
Okay.
Hmm.
So that was about prior art. I guess I have already overshot my time limit, so I will go a little. And I guess people are getting bored. I can see, and from the gray and white slides that I have made, I guess people are getting already bored. So I'll move to the next slide, and I'll go quickly. So here I wanted to talk about patent linkage, and yes, I will talk about it. Mm. So patent linkage is like certain countries like US, Canada, Mexico, China, Singapore, they give the option to the drug companies to list their patents on a certain molecule or a certain product, to list it in a like US has. This is, if you see this, I have pasted a book, an image of a book called Approved Drug Products with Therapeutic Equivalence Evaluation. This is called the Orange Book. This is like the Bible for all of us. So this book, which is now an electronic book, I have a picture of the electronic book as well. So I don't know how much like you would be able to see it. So so it gives the pharma companies, the MNC companies, the brand manufacturers to list their patents in the book and to say that we have this product and our product is covered by these patents. So then what happens is that if a generic company want to come into the market during the pendency, during the when these patents are in force, they have to challenge these patents. So in US, they have to file what is called a paragraph 4 certification. So when they file a paragraph 4 certification, they either have to say that your patents are invalid, or they have to say that what we are coming up with. So suppose they have a patent where they are saying that, oh, we are using mannitol, and so the generic company can say, no, we don't use mannitol, we are using lactose. So if they say that, and if the patent is specific to use of mannitol in that particular composition, so by virtue of using a different like excipient, because they are using lactose, so then they are out of the claim scope. So if they're doing that, so they say that we have not infringed your patent rights. We have not infringed. So then what happens is, what begins is the patent litigation process begins. And so these patent linkages, what it does is that it incentivizes both the brand manufacturers, the big pharmas, as well as the generic pharmaceutical companies, because they are giving the, because it can so happen that a frivolous patent can also be listed by a big pharma company, where like the patent itself should not have been granted. So they are giving us they are giving generic companies a chance to actually challenge those patents. And if you can prove in the court that these patents are invalid, so then the floodgates are open. Anybody and everybody can come. But because they're the first to challenge those patents by virtue of the paragraph 4 certification, so the US government will then, the US FDA will give them an incentive to that first company which has challenged those patents by keeping them in the market for 180 days. So it's called the 180-day exclusivity, which is like for 180-day, nobody else other than the brand and the generic company can be there in the market. Only it can be only the that particular generic company along with the brand. Because after that 180 days, if the patents are held invalid, anybody and everybody can enter into the market. It becomes like that. So this is if you, I don't know how many of you can see the picture of the orange book which I have pasted. So this is the physical orange book. uh, I have never held it in my hands also, because from the time that I have been in this field, I have always used the electronic orange book. And even now we have the app, the Orange Book Express. So we have never seen this actually. We have only heard about it and seen it in images and all. So and it's quite expensive, you know, to get it from the US, like the FDA to order it and all, when you have the entire information available electronically. So that are the small benefits of internet. So this is the electronic orange book page. I had actually pasted my company Sun Pharma's has a brand called Yonsa. It's like the molecule is abiraterone. So we have a brand product, a 505B2 called Yonsa, and we have patents listed against it. So I had listed it actually here, but I don't think it has become a very colorful slide. Thank you, whoever has done it. I got ideas to make it include the red and pink next time. I'll surely do that, and blue as well. So I'll move to the next slide. So which are the patents which can be listed in the Orange Book? So the patents which can be listed in the Orange Book or the US Orange Book, the US Patent Linkage Program, which is called the Hatch-Waxman program. The molecule patent, the composition patent, the salt patent, the polymorphs, the dose titration, the device, the drug device combo, all of it can be listed in the Orange Book. But your process patents cannot be listed in the Orange Book. So this is something which I wanted to just give everybody, make aware of what is there. This is a very brief like overview of how the patent litigation moves in US. uh, like the in US, once you have like the US FDA informs a generic company that your dossier that you have filed is a complete dossier, you have to immediately notify the brand manufacturer to mention that I have filed a dossier and I am challenging your patents. So the moment you do that, it will start your 45-day clock, which says that, and in that 45-day clock, they will determine, the brand manufacturers will determine whether they should sue you or not, because you are sending a notice. In that notice, you are saying why you believe their patent is invalid, or why you believe that your product does not infringe their patent rights. So they will evaluate with their legal team, their patent team, their legal general counsel, their general legal, and their patent counsels, people like us, they will work with, to determine as to whether they infringe or not. And then they might or they might not sue us, sue the generic company. So the moment they sue a generic company, so the moment the suit is initiated, the generic company will inform US FDA that we have been sued. So that what happens is, the when the patent litigation is ongoing, so US FDA will not approve your product, your generic product. So that's called the 30-month stay. So there'll be a 2.5 years of stay. So that stay is there so that you can resolve the litigation with the brand company, and then you can launch your product. Because at times what has happened is, earlier, before this hatchback smell litigation, US FDA used to approve the product, and then, like, these generic companies used to launch the product, and then they used to be enjoined, and then the US FDA also used to be brought into the litigation. Like, the brand manufacturers used to sue the US FDA as to how can you even approve their product when I have a like patent on this. So all these things were happening. So that is why this is the new regime. Though I'm saying it new, but it started in the year 1984. So since 1984, it has been in place. India doesn't have such patent linkage at all. It doesn't respect such things. So that is why you see any molecule which is there, Indian companies like launch it in India. So, oh yeah, I am about to come to the end of my presentation. So the career options that are there for the students, I don't know whether the students are there or they left for their lunch. Maybe they are hungry. Uh, so they can like students can join the patent department of any pharmaceutical company. So they can go into the so within the patent department of a pharmaceutical company also, we have certain sub departments. So like the patent prosecution, drafting and filing teams are there. So where who determines who will work with the R&D scientists. Am I audible? Am I audible?
Yeah,
Okay.
yeah.
Okay. Who will draft the patents? Like, if the scientist says, I want a patent for this, I have come up with a new thing, can I get a patent for this? So it's their duty, it's their role to draft a patent, prosecute it. And of course, that will happen with management's approval and the business team's approval. Then comes the patent litigation team, the FTO team. I am in one such team. So my job is to make sure that our scientists, what they are doing, they do not infringe anybody's patent. They do not, the job that they do, that they do not infringe any patent, or the product that we are going to launch, that it doesn't like infringe anybody's patent rights. So uh, like that is my job. And even if we feel that a patent is invalid, so even that is my job to say that no, we believe that this patent is invalid, or we believe that we can design around this patent, we can come up with a non-infringing formula, or we can come up with a non-different salt or something, and we can be outside the scope of the patent and still file the same product and still launch the same product. So then my job starts. Like my actually, if you see the patent team, the especially the FTO team, like the team in which I am in, and many like many of my colleagues are in, like our job starts from the inception when the product is selected itself, before the R&D scientists even like start working on it. When we work with the business development team and the portfolio team to identify such products, and to see whether like we have a good basis to challenge the patent or we can design around the patent, and our job ends. It doesn't end anytime actually. So our job, like till the product is launched, like till the supply chain launches, the new product launch team launches the product, our job is still there to support each and every department, from the business development to portfolio to the R&D scientists, whether organic synthesis or the formulation team, to the regulatory team with respect to certifications. We have to work, and we work very closely with the regulatory team, like the regulatory team of like where we have to tell them what kind of certification we are filing with respect to each patents, especially in such geographies like US, Canada, and all, where there is patent linkage in place. So we work very closely with them, we work hand in hand with them, and to the launch team we work with them. So after your B Farm, you can also go on to become a patent attorney. You can do your JD, Juris Doctor in US. You can pursue your LLB after your B Farm and M Farm here in India. You can join a law firm. You can also join the IP department. You are also needed. You can go on to become a patent agent. There are patent agent exams actually, which you can, and like once you clear that, you'll become a patent agent exam. uh, you can also join the portfolio planning team. You can also join the business development team, because awareness of patents is required to select a product and to decide as to whether you should take this product into your pipeline or not, and whether your portfolio should have, your company's portfolio should have this product or should not have this product. So awareness of patent is extremely essential. So you can, like one can also decide to join the portfolio planning team or the business development team. So generally the IP head is like only heads the portfolio planning and the management team. So that is at least in my company and many other such pharma companies like Glenmark, like the IP head and the portfolio head are one and the same person. So I guess with that, I come to the end of my talk. Here I had pasted a very small cartoon. I don't know. I don't think that many of you can see that. But like with this lockdown situation, when we are all working from home, you know, like this is very pertinent to me because I have a child, and these are the kind of questions which I am receiving as to what is a prior art. Like my daughter asked me, you go on shouting with your at your team member, prior art kahan hai, kaun sa prior art hai? And so this is the kind of answer that my daughter has received, very pertinent. So
Yeah.
thank you all. I guess there are, and these are the references which I have relied on to come up with this. So
Yeah. So, Devjani, thank you very much for. And now I think we have participants. So, Ramandang sir is here. Sir is raising his hand.
yes, I saw.
Yes, sir.
Good
Hello.
afternoon,
Hello,
sir.
sir. Hello, sir.
So you're
Raman
still
sir.
on mute.
Sir, Raman sir, please unmute.
Okay, am I audible
Yeah.
now? Fine,
Yes,
Yes,
sir.
fine,
sir.
fine.
Yes, sir. Good afternoon, sir. Welcome.
Okay, Sunday is the day we have to remain mute. We are at home.
Yeah.
So, welcome back home. It was a nice connect, and I could see
Thank you,
the
sir.
passion in you. It's very essential. What you do, it's important. Then only the outcome is good. No matter the slide, some miscreant has played some colorful game, or maybe the kid. We don't know. Sunday, no, the phone is with the kid, and the
I know.
it's on and somebody's listening. So all those things
Yeah.
go on online. It's part of it. But frankly speaking, I was very impressed with the talk because
Thank you.
Me and Sujit are always on the wife's duty. But then this talk was so impressive, I had to ask my wife to excuse me. Yes, please, I will do my
So
work, but after this
we
talk.
know.
So 2004 batch, great. So
Yes,
Yes.
sir.
Shilpa's batchmate, I suppose.
No, Shilpa Jatti, Jatti sir's daughter.
No, Shilpa Murthy.
She's from Belgaum.
She was your batchmate, Shilpa Murthy.
No,
No,
no.
I had one junior named Shilpa who was my junior.
Okay. But
Yeah.
2004 is quite a time now. I think nearly now 16 years.
Yes, sir.
Yeah, yeah. So how is it coming back to your own home?
Oh, it felt wonderful, sir. In fact, I didn't have the opportunity to meet you, but I did come down to